Okay, good afternoon. My name is Chris McCarty with the law firm of Lewis Thomason here in Knoxville, Tennessee, and you're joining us today to talk about hiring and firing in Tennessee. This will be a short presentation. The concept is to hit the high points of what I consider the most sort of dangerous and risk-laden area of HR law. That's what I do here in our Knoxville office of Lewis Thomason as I handle employment law for employers, either public side or private side. So if you ever need any assistance in that matter, anything gets a little more complicated, even if you have litigation, certainly give us a call. But we'll go ahead and jump right into it and talk about sort of the high points of this issue. I want to start with hiring. When we're looking at hiring issues, and there's lots of laws we have to consider, but I like to think about the big three, because as long as you're complying with the big three, as I call them, usually you're going to be in compliance with most of the issues that you could run into in a hiring world. Okay, so the big three are Title VII of the Civil Rights Act, the ADEA, which is the Age Discrimination and Employment Act, and then the ADA, which is the Americans with Disabilities Act. We also have the Tennessee Human Rights Act, but candidly, if you're in compliance with those other laws I just named, which are federal, you're also probably going to be in compliance with the Tennessee Human Rights Act. It is Tennessee's version of workplace protection laws for things like protected classes. And when I say protected classes, that's really what we're talking about here. We're talking about areas in which just to stay away from, to not get into, to not consider at all under the law, and when you're making these hiring decisions. So for example, in Title VII, a lot of you can probably name it, but that's going to cover things like race, religion, sex, gender, national origin, all those type of things that we typically think of that goes all the way back to the 1960s in terms of employers, either public or private, are not allowed to consider those things in determining whether to hire someone or to not hire someone. ADEA is a similar law, but it's about age. Always like to remind people there is no such thing as young person age discrimination. No offense to anybody out there, you know that that's not going to apply to me anyway. But the ADEA only applies to employers over the age of 40. So what you're not allowed to do in the American workplace and looking at hiring decisions is consider somebody's age if they're over 40 in the hiring decision. You can do that, absolutely, if they're under the age of 40. Why do we do that? Why is the law set up that way? Because if we didn't set it up that way, you could never account for experience, right? Let's say you wanted 10 years of experience for your controller position at your boat company. Well, if you wanted 10 years of experience and we made federal law to where you can't discriminate against somebody that's younger, you got a problem. You can't ask for experience. You can't require a certain minimum level of experience. So to have those at least minimum levels, the feds have basically said, we're not going to start the clock on age discrimination until at least the age of 40. And then lastly, obviously, is the ADA, which is the Americans with Disabilities Act. That's going to be just making sure you're not making any decisions whatsoever based on disability status. I could spend days talking about the ADA. It is by far the law that I deal with the most as a workplace attorney. And what do we look at there? We're talking about, it's bigger than just somebody walking in with a visible disability. And I hate to put it that way, but you know what I mean. If somebody's walking in and they're on a walker, if somebody's walking in and they have a pronounced disability, maybe their left arm doesn't work, or maybe they're, I'd say, missing an arm, or they're in a wheelchair. Clearly the ADA applies to those employees, but the concept of disability under the ADA is way broader than that. It's honestly uncorrected vision. I always joke that if you give me 10 minutes with somebody's medical records, I could probably prove that you have a disability under federal law. It's just not a high bar. So we can't consider any of those things as we look for someone coming in unless there's a physical component to the job which requires the person to perform certain physical tasks as an essential function of that job. So example would be, if you have a maintenance person, notice how I said person and not man. It's also, we don't say those things anymore, and you can't really even advertise it that way under Title VII. But if we have a maintenance person, you might say in the job description, you have to be able to regularly lift 50 pounds or more. So that's going to cut out certain types of people with disabilities. But unless it's truly not related to the job and related to the functions of the job, then we're supposed to be open to employees who have those disabilities and making sure we accommodate them in the workplace, even during the hiring process. All right, so I like to give examples of my sort of stay away questions that you never want to ask during an interview. And there's a lot more than this, But this gives you a broad brush of sort of the ones that clearly you don't ask. In the South, the number one that I always start with is do not ask people where they go to church. I totally understand why you do that. I totally understand that if we meet each other and for lunch, that might come up. But when you're going through the hiring process, religion is clearly a protected area under Title VII, and it can't be part of your decisions. So if you ask everybody that comes in where they go to church, and the only person that doesn't get hired out of the four you're looking for is the person who happens to be an atheist, or the person who happens to be a Christian or a Catholic or whatever, then that person can then assume or might assume that you made the decision based on religion. Now, you probably didn't. It probably had to do something else. But because you asked that question, now they can file a charge with the EEOC, and they're going to ask you questions about, why did you ask that if it's not part of the process? If you didn't care and that's not what you were looking at, why ask the question? So just stay away from that. Same thing, similarly with what are your plans on starting a family? You know, what somebody does with their family decisions, especially with gender roles, is frankly none of our business and can fall under Title VII. Is retirement something you're going to consider in the near future? That's going to come across, not so professional to an older employee, but it also indicates maybe you're not looking for somebody at that age because you're worried they're going to retire. And you're not allowed to consider that as part of the process because, again, that would be a form of age discrimination. If you said something like, why do I want to hire a male nurse? Well, first of all, you've seen, Meet the Parents too many times, and you're imitating Robert De Niro, but it's just not an appropriate question. Don't consider those gender roles, those stereotypical gender roles, when we look at this process. Again, this is not something that is brand new. These are things that have been off limits really for decades, because we go back to Title VII in 1964. And again, same thing there. Don't mention if somebody I can't imagine you would, but I've seen in my life and doing what I do, I've seen some unbelievable questions that are asked in this process, so I throw them all up there. If somebody has a physical disability, certainly don't bring it up. If somebody doesn't have one, don't ask. You don't want to say, hey, is there any health conditions or anything we need to know about as we move into this process? That's just not appropriate. You're not allowed to consider that as part of it, unless, again, you're focusing on, is this part of the essential functions of the job? All right, focus instead on what I call the 3 Ps: professional experience, performance history, and personal character. As long as your questions fall into those typical 3 categories, you're usually going to be fine. So professional experience, looking at a resume, what have you done before? Where have you worked at? Who are the people I can call? What are the types of things you've done in those areas? Then we move to performance history. Tell me what you've learned. What type of accomplishments have you brought about, or have you accomplished in those previous jobs, or maybe even in college? And again, personal character. You can ask questions about whether someone has an arrest record, whether somebody's ever, been arrested or been convicted of a crime. You can ask questions about their truthfulness, if they've ever been involved in any sort of lawsuits, depending upon whether or not they're workplace related. So we do have to be careful there. But getting into the general frameworks of character typically is okay. Just be a little careful when we go into the legal process. All right, now we move into firing. Don't forget those protected classes. We got to revert back to that every time. So sex, orientation, that's sexual orientation. We'll talk about that. Gender, religion, race, national origin, age. The same big 3 apply in the firing process as well. So when you're determining whether you're going to fire somebody, even though a lot of you right now are thinking, I thought Tennessee was an at-will state. It is, but you can't fire anybody or take an adverse employment action based on any type of federal protected class, right? And that's the ones we just showed you. So age, etc. I bring up orientation because since 2 years ago, the United States Supreme Court, as part of Title VII, has considered that sexual orientation and gender identity are also protected under that law. So we can't take those things into account in the firing process or in the hiring process. And again, that's not me talking, that's the United States Supreme Court. All right, 3 common mistakes that I see in the firing process. And we're moving quickly because that's the point. This is an overview. I call it nice guy, nice girl syndrome. What do I mean? That means by the time you got there, you really haven't documented enough to get to a good firing decision, especially if somebody falls within one of those protected classes. Because right now you're thinking, well, if it's at will, I can fire them from no cause. That's true. Well, here's what happens. If you fire somebody that's clearly in a protected class and they file a lawsuit or they file an EEOC charge, which is completely free, then the agency or the court is going to ask you, well, why did you fire them? And if you don't have good documentation explaining that it was not related to protected class status, then we're going to have a problem. So document, document, document. If you're doing performance reviews, I need you to be blunt. I don't need you to be Southern all the time, just like I am, and make sure you're only being nice. I need you to say if they have a problem. Knee-jerk decisions sort of falls into the same category, but it's really rare that I tell somebody that it's a good idea to fire somebody out of lark. Okay, think about it. Now, obviously, if somebody comes in and they start a fight in the office or somebody gets arrested, there are certainly extreme situations that you have to move quickly. But most of the time, you want to be careful about it, get your documentation in place, and don't just have a knee-jerk decision. And then the last thing is, and this is just good practice, before you fire somebody or during the process, do an exit interview. We find over and over again statistically that if you do those exit interviews and you let people say their piece, even if it's not pleasant for you, just let them say, basic question of, tell me what you would do differently here at this workplace. Tell me what we could have done differently for you, and you let them vent. We find over and over again, if they walk out of there feeling like they said their piece to you, they're less likely to file a lawsuit. They're less likely to file an EEOC charge. They're more likely to just move on with their life. That exit interview, as painful as it can be, is very valuable, and it's going to save you some money. And again, the last thing I'll say about firing is I've never had a client that's thought it through and decided to do it, regret it. By the time usually clients get there, it's past the time when they should have already done it. Okay, if you have that dark cloud of an employee hanging over your office, it's amazing how quickly that cloud goes away when you finally make the hard decision to let them go. And that's our presentation today on hiring and firing. Again, my name is Chris McCarty with the Knoxville firm of Lewis Thomason. If you ever have any questions or concerns, a little more complicated than what we talked about today, certainly contact us anytime. Love to help you out.